Everybody ready to start? Yes? Well, welcome to everyone who's connected to this event this evening. It's so wonderful to have you with us today. For those of you that don't know me, my name is Rosa Celori, and I'm actually Associate Dean for International and Comparative Legal Studies at GW Law School. And I first want to start thanking our LLM student, Mariam Nakra, who actually conceptualized this event and was able to not only secure the amazing speakers that we have today, but to give a lot of life to the discussion that we're going to have today. So I commend you, Mariam. We're so lucky to have you as a student at GW Law School. And she's also going to be providing commentary after our speakers have a bit of a discussion on the issue that we're discussing today. And today we are focusing on the problem of enforced disappearances and its connection to COVID-19. And of course, we are going to have a discussion related to international law and human rights issues connected to this particular topic in particular. But first of all, I actually want to introduce our speakers because I'm so honored and privileged that they have accepted our invitation to be with us today, especially in the middle of a pandemic. I know the three of them are extremely busy, so I feel very lucky to be in their presence today. So I'm going to introduce them by alphabetical order, by first name. First of all, I want to introduce Carmen Rosa Villa, so that in many ways is a legend in human rights in Latin American issues. She's an icon in many ways for those of us that have been working on human rights in the Americas. She's currently a member of the United Nations Committee of Enforced Disappearances since 2019. And she also dedicated more than 20 years working and holding leadership positions in the area of promotion and protection of human rights at the United Nations in different countries throughout Latin America. And she also has extensive experience working with the Peru Justice System Administration. We also have with us today Nerea Aparicio, who I actually had the privilege of working with for more than a decade at the Inter-American Commission on Human Rights. And I have an incredible amount of respect for all of her work and achievements career-wise. She's currently founder and director of Rights and Governance, All In for Development. She was also the director of the Latin America program for the American Bar Association Rule of Law Initiative, and also a senior specialist for the Inter-American Commission on Human Rights for more than a decade. Nerea also has a very distinguished career working for the United Nations throughout Latin America in the area of human rights issues. And we also have today Dean and Professor Rangita da Silva de Alves. She's actually a very well-recognized name in the gender field. I follow her work very closely. She's a globally recognized expert in this area. She also serves as an associate dean and professor of International Affairs at the University of Pennsylvania Law School, where she teaches international women's rights and has been appointed leader in residence at the Harvard Kennedy School's Women and Public Policy program for the 2019-2021 academic years. She also serves as advisor to the National Security Council on addressing legal barriers that preclude women's economic participation in developing economies, with an emphasis on Africa. And in 2017, she started the Global Women's Leadership Project and the Women Law and Leadership Lab under the auspices of UN Women, and is executive director to map laws that regulate the status of women in the family. And I could keep on going on.
Stop.
Really long time. It's wonderful to have them here today. I also want to announce, before I share some introductory remarks with all of you, that this is a bilingual event. So our speakers are going to be sharing their remarks both in English and Spanish, which is very exciting, especially for a program like mine, our international law program. Please keep your microphones on mute. And if you have any questions, please feel free to actually write them down in the chat, because we're actually going to have some time to do questions and answers towards the end of this event as well. I just wanted to say a few things as an introduction to the topic that we're going to be discussing today. As you all know, COVID-19 is a health pandemic of epic proportions and a widespread crisis. It's also a global issue. There are more than 44 million cases confirmed worldwide and more than 1 million deaths at this point. I hear some noise. If you could all mute your microphones, that would be great so that we can preserve the bandwidth and the flow of the conversation. This is also a pandemic that has actually caused a very radical change in the way we live and also in the way our states act in many ways. And I want to say a few things about enforced disappearances. Enforced disappearances were already some of the most serious, widespread, alarming, and painful human rights violations around the world before COVID-19. So COVID-19 didn't necessarily create this problem. It just has worsened many aspects of this problem. And I think that disappearances pose particular hardships for the relatives of the missing person. They can live in a state of uncertainty for years, sometimes decades, not knowing the fate or whereabouts of their loved ones. And also local investigations of disappearances are often plagued by delays, omissions, and irregularities. And all of this is very worsened by COVID-19. And a lot of the effects are going to be discussed today. There are many government actions that have been put on hold because of COVID-19, including the search and investigation of enforced disappearances. And many victims and family members have been forgotten in this time of crisis. And there's also been a lot of new allegations of new enforced disappearances as well during the COVID-19 pandemic. When we're thinking of enforced disappearances, we are thinking about all these human rights that are involved, including the rights to life, dignity, personal integrity, to be free from violence and discrimination, the right to truth, and to judicial protection and guarantees, among others. Thank you so much for being here. Gracias por estar acá. And I'm going to start with the first question for Carmen Rosa Villa. Carmen Rosa, I wanted to ask you to please discuss how the United Nations treaty-based and charter-based organs are addressing COVID-19 and the problem of enforced disappearances.
Thank you, Rosa. It's a pleasure to be here, and thank you to Marian, too. She's a student in law, for your kind invitation to be a part of this panel. I'm delighted to share this space with distinguished panelists and audience. As you know, I will speak in Spanish. Bueno, como todos sabemos, la desaparición forzada no es un fenómeno del pasado y como tú lo acabas de señalar, es también un fenómeno del presente y una situación que preocupa al universo entero por su recurrencia. El número de casos que se vienen presentando al Comité de Desaparición Forzada, pero también al grupo de trabajo, nos hacen pensar en qué estadio nos encontramos y qué podemos hacer y qué se ha hecho frente al tema de la desaparición forzada en el marco de la COVID-19. El 24 de marzo de este año, después de los pocos días en que se declaró la alarma mundial, la pandemia acerca de la COVID-19, los y las presidentes de los 10 órganos internacionales de derechos humanos, en virtud de los tratados, definieron las medidas concretas que los líderes del mundo deberían adoptar para abordar las amenazas de la pandemia, que supone inclusive no solo la salud pública, sino todo el impacto que tiene en la vida de las personas. Señalaron en ese momento que el estado de emergencia o cualquier medida de seguridad debe guiarse por los principios de derechos humanos. Me parece muy importante tener en cuenta que a pesar de esas decisiones que se tomaron por los estados del confinamiento, del seguimiento y del control de la policía, esto no podía dejar de lado los derechos humanos. Y le recordaron también a los estados que la imposición de controles estrictos que afectan los derechos humanos deben de realizarse dentro del marco legal válido y en caso que los países declaren el estado de emergencia, esta declaración debía ser excepcional y temporal y estrictamente necesario y justificada por una amenaza a la vida de la nación. Elementos que son muy importantes porque el 30 de abril, es decir, un mes después de este pronunciamiento de los presidentes, el Comité de Derechos Humanos hizo una declaración sobre la suspensión de obligaciones dimanantes del pacto en relación a la pandemia del COVID-19, recordándole a los Estados partes los requisitos y las condiciones establecidas en el artículo 4 del Pacto Internacional de Derechos Civiles y Políticos y en sus observaciones generales, en particular la observación general 21. También recordó a los Estados partes que no pueden suspender sus obligaciones de tratar a todas las personas, incluidas las que están privadas de libertad, con humanidad y con respeto a su dignidad humana. Cabe destacar que todos los órganos de tratados y los titulares de procedimientos especiales han presentado análisis pertinentes a su mandato y sus obligaciones frente, o sea, las obligaciones de los Estados partes frente a la COVID-19, perdón. El Comité para la Eliminación de la Discriminación Racial, como ya lo había dicho la profesora Ranguita, también la CEDAW, tanto el Comité de Trabajadores Migratorios, el Derecho de los Niños, es decir, todos los comités se han pronunciado, pero también han abordado sobre todo algunas guías sobre, por ejemplo, la detención de migrantes, niños, personas LGBTI, mujeres, personas con discapacidad, entre otros. Es decir, hay un abundante desarrollo de estos asuntos y la situación de la COVID-19. Y de la misma forma lo ha dicho también el secretario general de las Naciones Unidas, la alta comisionada de Naciones Unidas para los Derechos Humanos. Y en cuanto a lo dicho por la alta comisionada, me gustaría subrayar lo siguiente, al señalar que la situación de emergencia no es un cheque en blanco para hacer caso omiso a las obligaciones en materia de derechos humanos. En las próximas semanas tendremos el examen periódico universal, porque como ustedes saben, en el marco de la pandemia se suspendió y se ha vuelto a retomar, y ahí estarán países como Bielorrusia, Honduras, Estados Unidos, Panamá, Mongolia, varios países. Esta será una gran oportunidad, sobre todo en el diálogo interactivo entre los miembros del Consejo y de los Estados, para conocer cómo los Estados están abordando la COVID-19 e incluso sus obligaciones respecto de la desaparición forzada. De otro lado, la OACNUD, la Oficina de la Alta Comisionada, ha desarrollado una serie de directrices para ofrecer una respuesta global a la pandemia centrada en las personas, elemento fundamental, señalando que las estrategias de salud pública deben abordar no solo las dimensiones médicas de la pandemia, sino las consecuencias inmediatas a mediano y largo plazo sobre los derechos humanos y las cuestiones de género que pueden tener las medidas adoptadas en el marco de la respuesta humanitaria, sanitaria. En este contexto, el Comité contra las Desapariciones Forzadas y el Grupo de Trabajo contra las Desapariciones Forzadas Involuntarias expresamos nuestra alarma por las denuncias de desaparición forzadas recibidas en el contexto de la pandemia y la suspensión de facto de las medidas de búsqueda y de investigación de las desapariciones. Ello debido a las restricciones adoptadas a partir de la pandemia, tales como el confinamiento, como señalé, o el despliegue de las fuerzas de seguridad para controlar su aplicación, afectando, de hecho, la capacidad de acción y de reacción de los familiares y allegados de las personas desaparecidas, pero también de las organizaciones que la acompañan y de las autoridades encargadas de la búsqueda e investigación. La desaparición forzada de las personas, como todos sabemos y tú lo has mencionado al inicio de esta presentación, Rosa, es una de las más atroces violaciones de derechos humanos. La persona desaparecida no es la única afectada por este crimen. Su comisión vulnera los derechos de los familiares y de las otras personas cercanas a la persona desaparecida, valga la redundancia. Se ha señalado en este marco y en este pronunciamiento que hemos hecho en conjunto, comité y grupo de trabajo, que la falta de acciones inmediatas para la búsqueda de personas desaparecidas ocurrida en el contexto de la pandemia reduce las posibilidades de encontrar a la persona con vida, con la consecuente victimización para los familiares y allegados que ven frustrados todos sus esfuerzos debido a la inacción de las autoridades. El comité ha hecho hincapié sobre la prohibición de la desaparición forzada, señalando que no podrán invocarse circunstancias excepcionales de ningún tipo, ya sea de estado de guerra, amenaza de guerra, inestabilidad política interna o cualquier otra emergencia pública para justificar las desapariciones forzadas. Principio que también se aplica al contexto de la pandemia de la COVID-19. También se ha señalado la necesidad de adoptar medidas específicas para prevenir las desapariciones forzadas y respetar los derechos de las víctimas, ya que a menudo estas son olvidadas y sufren al no saber la suerte o el destino de sus seres queridos desaparecidos. Hemos exhortado a los Estados miembros a seguir respetando las obligaciones internacionales durante la pandemia y a actuar de forma decidida para prevenir, buscar e investigar sin demora las desapariciones forzadas. En las actuales circunstancias, todos los actores, es decir, el que busca, los que investigan, los familiares, los allegados de las personas desaparecidas y las organizaciones experimentan una serie de obstáculos, los que de ninguna manera pueden ser usados como excusa por parte de los estados o pretexto para no cumplir con su obligación de búsqueda e investigación por tratarse de obligaciones continuas que deben llevarse a cabo sin demora, tomando, por supuesto, las precauciones sanitarias necesarias. Tanto el comité como el grupo de trabajo han subrayado a los estados su obligación de garantizarle a los familiares de las personas que han fallecido como consecuencia de la pandemia que pueden ser identificadas, que los restos se traten de acuerdo a su religión, a su tradición y a su cultura. Al tiempo se ha hecho un llamado a los estados también para que en estos tiempos de crisis las familias de las personas desaparecidas sean más apoyadas, empoderadas y que las instituciones estatales encargadas de la búsqueda y de la investigación cumplan sus funciones sin demora. Para cerrar la pregunta que me acabas de hacer, Rosa, es importante que los estados deben abordar todo esto con celeridad, de manera proactiva, incluso con la aplicación de programas específicos para mitigar los efectos multifacéticos de la pandemia. Thank you so much.
Thank you so much, Carmen Rosa. And I wanted to highlight some of the points that you just very in a lot of detail shared with us. I mean, one of the things that I think is very important from what Carmen Rosa just stated is the need for a human rights approach when it comes to the problem of enforced disappearances and how active the United Nations bodies, including both the treaty-based organs and the charter-based organs, have been in actually highlighting specific issues related to enforced disappearance, but also their connection to COVID-19. And one thing that's very interesting that she highlighted about COVID-19 in particular is the fact that even though our governments have shut down, even though our societies have shut down in many ways, there is a continuity of human rights obligations, especially cornerstone obligations like the right to life and the right to human dignity and the right to personal integrity and the right to justice and non-discrimination and violence. A lot of our big cornerstone or foundational rights, these obligations continue for states even during times of crisis and even during times of emergency. And one thing also that we were discussing before beginning this event is how active United Nations bodies have been. I mean, the fact that this pandemic has given the United Nations an opportunity to really be vocal and present and to raise awareness about problems that continue to be lingering problems like enforced disappearances. And another thing that I wanted to highlight is the family members. When you're thinking of enforced disappearances, you're thinking about all these web of persons that are suffering because of this enforced disappearance, but also the lack of justice and the failures and delays of the justice system, and also the importance of prevention. At the end of the day, when we're thinking of enforced disappearances, as Carmen Rosa stated, we are thinking of prevention as well, and the need for states to be proactive in this prevention as well. So Nerea, I wanted to turn to you because you have all this experience, with the regional human rights protection systems, and particularly the system in the Americas that has been really in many ways the leading system when it comes to the development of regional standards related to enforced disappearances. And it has had such an enormous impact on what has happened globally with this issue as well. So I wanted to ask you to please describe for us some of the main regional human rights standards connected to the problem of enforced disappearances. And I also wanted to connect a little bit also with COVID-19 and what groups of the population you think are more at risk to enforce disappearances when you have a time of crisis like the one that we have, COVID-19.
Thank you, Dean Delorio, and I'm very grateful to be in this such an honored panel. So, I mean, your questions are very interesting. There is kind of a broad subject, so I will focus on the main principal Inter-American standards on forced disappearance, based on the limited time that we have. I want to highlight the concept of enforced disappearance began at the UN level in the 70s and 80s, but the development of the jurisprudence about this crime against humanity was developed by the Inter-American Court on Human Rights based on some the Honduran cases that began in the 90s, 80s. So I have because this is a very common subject. I think that maybe I can share with you my screen and put a very rustic a slide. So just to provide with a concept of enforced disappearance at least at the Inter-American level. Well, the Inter-American Court in its constant case law on cases of forced disappearance of persons, the court has reiterated that enforced disappearance constitutes an illegal act that gives rise to a multiple and continuing violation of several rights protected by the American Convention and place the victim in a state of complete defenselessness, giving rise to other crime. And this crime constitutes a radical breach of human rights treaties and shows a crass abandonment of the concept of human dignity and the most basic principles of international law, democracy, and rule of law. The prohibition of the forced disappearance of persons and the corresponding obligation to investigate and prosecute these or those responsible have attained the status of jus cogens. So, I mean, we are not dealing with an ordinary human rights violation. I mean, it's a violation that really represents the denial of the rule of law, of international law, of a democratic society. So, but which are the core elements of the enforced disappearances? Let me go. So, the dispute that is presented before the courts consists as to whether the presumed enforced disappearance of a person occurred, and if so, whether it can be attributed to the state. Under the definition of the UN Working Group on Forced and Involuntary Disappearances, the UN Declaration on Protection of All Persons Against Forced Disappearance, the Inter-American Convention on Forced Disappearance, the jurisprudence of the European and also the Inter-American Court on Human Rights, there are three concurrent and constitutive elements of forced disappearance: the deprivation of liberty, the direct intervention of state agents or the acquiescence of this, and the refusal to acknowledge the deprivation of liberty or conceal the fate or whereabouts of the disappeared person. So with regard to the deprivation of liberty, I think is a very important standard that all enforced disappearance of persons begin with a deprivation of liberty, contrary to Article 7 of the Inter-American Convention of Human Rights, or is Article 3 of the European Convention. But the individual deprivation of liberty should be understood as merely the beginning of the constitution of a complex violation that is prolonged over the time until the victim's fate or whereabouts are known. So any form of deprivation of liberty satisfies these first requirements. It doesn't matter if it's legal, illegal, or is it an arbitrary detention. And based on the jurisprudence of the Inter-American Court, also, it is important to keep in mind that the analysis of a possible forced disappearance should not focus on possible violations in isolated, divided, and fragmented manner, but rather on all the facts that they are present on the case, which means like we don't need to focus only on the right to life, right to liberty, right to integrity, right to legal personality. We need to see all the facts and everything how it's related, because it's a very complex and interrelated violation. Regarding the second element, the direct intervention of state actors or the acquiescence of this. So in order to determine the occurrence of a forced disappearance, the plaintiffs need to provide some elements to corroborate that the person was deprived of his liberty with the participation of state agents or by private individuals who act with authorization, support, or acquiescence of the state. So the context of systematic and generalized practice of forced disappearance is not enough by itself. So the plaintiff needs to tailor the circumstances in which the forced disappearance occurred to this context. And for doing this, it is legitimate, and it has been accepted to use circumstantial evidence, indications, and presumptions to substantiate a complaint. So Truth Commission reports, National Human Rights Institutions reports, UN reports on a specific situation can help to provide it context, but after, the plaintiff needs to tailor that context, the facts of the case to that context. And the plaintiff has the burden of providing the facts on which his allegations are based. However, the Inter-American Court has underlined that in cases of human rights violations, the state's defense cannot rest on the impossibility of the plaintiff to present evidence when the state controls the means to establish the fact that have occurred in its territory. So it's not all it's shift the burden of proof. Regarding the third element, the refusal to acknowledge the deprivation of liberty or conceal the fate or whereabouts of the disappeared person, it is important to note that this element must be included in the statutory definition of the crime at the domestic level. This is important in order to distinguish forced disappearances from other crimes that normally people confuse as kidnapping or abduction or even murder. Enforced disappearance is a different crime than those crimes. So the thing is this element provides this kind of differentiation with kidnapping or abduction. And whenever there is a reason to believe that a person has been subject to forced disappearance, an investigation must be conducted. And the states have the obligation to investigate the case ex officio and without delay and in a serious, impartial, and effective way. So in this slide, because I'm running out of time, I provide like some of like the difference between the European and the Inter-American system, which there are not many. For instance, the Inter-American court jurisprudence establishes that the analysis will focus on all the facts of the case, all the elements of the case, while the European court jurisprudence tells us that the court assesses on whether the offense encompasses only a substantive violation of the provision or a procedural one, which means the investigation. So divides into a substantive and a procedural violation. And in terms of the violation, in both systems, the victims are the people who disappear and also the family members or next of kin. And the Inter-American system has provided a major, or a broader inclusion of rights in the definition of enforced disappearances, and you have it there. So regarding your second question, Rosa, which is really interesting. So which groups of the population are more at risk to be victims of enforced disappearances? And I'm going to stop sharing. Well, I don't have a magic ball, and I wouldn't like to scare anyone in the audience. And I don't want to I don't know, deserve anybody in the world to be subject to a forced disappearance. So I'm not going to do this kind of thinking. But looking back at the victims of enforced disappearance in the Inter-American system, the identification of groups of population that would be more risk of being subject to this crime will depend country by country. So for example, in countries where there is not a democratic government or where there is not a clear separation of powers or the legal remedies are not existent, we have seen that people with dissident political opinions and journalists have been targeted for forced disappearance. And in the context of COVID-19, as Carmen Rosa has been pointed out, the declaration of states of emergency, whatever is the denomination in internal law, can create a risk and an opportunity to commit this kind of crime. So due to the pandemic, many states in the region and also in Europe and in other countries around the world have declared the state of emergency and restricted the freedom of movement and assembly. No, so it's what we call social distancing and mandatory confinement, but also freedom of expression, access to public information and other rights. So it's we really need to watch all these measures and how they have been established. And I think that what is really important in this context is that we need to keep in mind that some of the rights that cannot be suspended are the judicial guarantees, including the habeas corpus, which is the key effective remedy for finding a disappeared person or an enforced disappearance person, as well as access to justice and due process. And those rights cannot be suspended. So I think that is key on how the judiciary is going to react to this state of emergencies to control like the powers or the extra powers that these states are taking in name of combating this pandemic. And unfortunately, in the Americas, like we have the first case of enforced disappearance in April. It's a case that that it has been known through the precautionary measures mechanisms by the Inter-American Commission on Human Rights and also the UN Committee on Enforced Disappearance. And it's the disappearance of like a 22-year-old man who disappeared in Argentina. So Facundo Jose Astudio Castro disappeared on April 30 in the context of the state of emergency. He was traveling, he was traveling in a time that he was not supposed to travel. And the last time that he was alive, he was with some like police, it looks like police detained him because of this violation of the lockdown decree. And the commission, the Inter-American Commission on Human Rights, granted this precautionary measure on August 1st, but unfortunately, his remains appear in September. This is the case with the mother has been doing everything to try to find out. And unfortunately, I mean, there is no case or there is not a court decision on this case because it's very recent. But looking at the preliminary investigation, there are a lot of delay in conducting some of the investigation and in trying to locate this young man. So that's very sad. So I'm going to leave it here, Rosa. Thank you.
Nerea, thank you so much for that wonderful overview of what enforced disappearances are, the way the regional protection systems have dealt with them, especially the Americas, and the leading role of the Inter-American Court of Human Rights, but also, you know, the realities of enforced disappearances today and the context which really breed enforced disappearances as well. I mean, the conditions that really promote or facilitate that we have a problem of enforced disappearances. And I actually want to ask a connected question to Professor Da Silva about women in particular, because we know that women, first of all, they're not a group. It's more than half of the world's population. And we know that times of crisis tend to be breeding grounds for the worsening of many women's rights violations. And we know that they have a history of discrimination and gender-based violence in the first place. So how do you see the connection between the problem of enforced disappearances and the situation of women in particular?
Thank you, Dean Rosa. And as you know, you and I share a student, a very dear student, Miriam. So thank you to both of you for inviting me to GWU and for GWU for hosting this important conversation at a critical moment in history. I want to start by marking the dual forces of the pandemic and the mass public reckoning on race and gender, because I think these dual forces impact both our conversations and the enforced disappearances. We are also marking several anniversaries, the 75th anniversary of the United Nations and the Universal Declaration of Human Rights, the 20th anniversary of UN Security Council Resolution 1325 on women, peace, and security. And I see enforced disappearances falling at the very epicenter of the women, peace, and security agenda. And we need to see the intersections of the women, peace, and security agenda and the Convention on for the protection of all persons from enforced disappearances. So as the world remains teetering on its edge, the Secretary General, Guterres, last month at the assembly, at our General Assembly, called upon all nations to acknowledge this moment as our 1945 moment, as the year 1945 when we were in war, the Second World War. But I would like to say that this is our Nuremberg moment, a time for a new vision for the world, a time to rebuild the world along the lines of justice and peace and equality that you spoke of, Rosa, and to look at the bedrock of human rights as the normative framework in rebuilding our work. So as we speak of the historiography of COVID and of this moment, it is important to note that the working group on enforced or involuntary disappearances, was begun 40 years ago. It was created in 1980, exactly 40 years ago, and was the first UN human rights thematic mechanism established. And it was created by then the Commission on Human Rights, the precursor to our current Human Rights Council, in the aftermath of the large-scale disappearances occurring in Latin America. But what we have to keep in mind are the stories of women, the histories of women, the narratives of women. It all started with a group of 14 women who wanted to know where their sons and daughters were, whether they were alive or dead. And these 14 women spawned a movement and international institutions. So these brave mothers marched on Plaza de Mayo on Buenos Aires, and they spawned both the working group as well as everything that has occurred since that time, that moment in time. So I am mostly delighted to be speaking at this moment in time because I can speak the names of women. And it is important for us to give voice to these women and to speak the names of these women. And I'm going to use the names and the stories of two women as the kind of starting point, as the narratives of all women who are both victims of enforced disappearances and those who are the women's human rights defenders of family members who have been forced to disappear. So we have women at both ends of the spectrum. So I wish to speak the names of Nazrin Sotoudeh of Iran and Talia Khatak of Pakistan. Nazrin Sotoudeh is a woman who was jailed in the notorious Evin prison because she dared to represent women who dared to remove their hijab in public. And she today has been sentenced to 33 years in prison and 146 lashes. And just last week, she was removed from Evin prison to a prison that is yet to be named. So what I can do best in honor of Nazrin Sotoudeh, because the more we say her name, the more we are able to recall her story, the more we ensure her release. So when I was speaking with my Iranian friends who are human rights defenders here in the US, they told me that I should say her name again and again. So in this forum, in this August forum, I would like to again recall Nazrin Sotoudeh and recall her story. And writing to the Time magazine, she wrote, on a late spring day in 2018, a group of officers from the Iranian prosecutor's office and the Ministry of Intelligence came and arrested me while I was home alone. They took me to Evin prison in a green taxi, in absentia. I had been sentenced to 5 years in prison for my work as a women's rights and human rights attorney. A few months later, 7 more charges were added, and I was given a total of over 33 years in prison, plus 148 lashes. The heaviest of these sentences was 12 years for promoting immorality and indecency. And the immorality and the indecency was that she was representing women who were refusing to accept the mandatory hijab rule and were removing their hijab in public. So on this International Women's Day, Nazrin wrote, as a deadly virus sickens my country, I throw my hands down, and as a citizen, in a gentle voice, I ask the government to end their animosity with the world, to look at the world through the eyes of peace and to trust life and human beings. So it is once again Nasreen's plea, as Rosa mentioned earlier in the afternoon, for a more multilateral, global world that looks at these issues as interconnected. Then I want to speak about Pakistan's Talia Khattak, because she's the face of women whose families are disappeared. And often it is women, the daughters, the mothers, the sisters, and the grandmothers who then become, who seize the role of a human rights defender for their families. And Pakistan's Talia Khattak writes for Amnesty International, my father Idris Khattak, a devoted human rights defender and the most selfless man I know, was forcibly disappeared on 13th November 2019. I have not heard from him. No one has any idea where he could be. We don't even know who took him. In Pakistan, enforced disappearances have been used as a tool to muzzle dissent and criticism of the state. People are just abducted by the very institutions that are supposed to protect them and placed outside the law. There is no arrest warrant, no record, no investigation, as if the person never existed. So these are the stories of women. And as Rosa mentioned, we have to look at the legacy of COVID in reimagining a new world. And in this new world, I see the blurring of lines of work and family and work and home and public and the private. And the focus being brought upon once again to the family and the familial and the rights of the family. So what I would like to recommend, and this is a very radical recommendation, that in interpreting the International Convention for the Protection of All Persons from Enforced Disappearances, that we bring the focus on the family of those disappearances, for the disappeared. So, you know, when we look at the protection of all persons from enforced disappearance, I do not see a single mention of the family. In Article 7, we see in 7b, without prejudice to other criminal procedures, aggravating circumstances, in particular, the event of the death of the disappeared person or the commission of an enforced disappearance in respect of pregnant women, minors, persons with disabilities, or other particularly vulnerable persons. But what we do not see in the language of the convention is that most often these persons who are disappeared leave behind their families, pregnant women, mothers, and sick grandparents. So the importance of family as a locus of attention needs to be addressed in the interpretation of this convention. Secondly, the guiding principles for the search of the disappeared, which was promulgated in 2019, in principle 4, looks at an interpretation of the guiding principles through a gender perspective. And it says in cases involving adolescent girls and women who have disappeared or are involved in the search, all stages of the search should be conducted with a gender perspective, and staff, including female staff, who have received proper training. And as much as that is laudatory, and as much as I applaud it, I think it is important that these principles, these guiding principles, also shine a spotlight on the women who are left behind in this act of disappearance. And then finally, I would like to look at Article 7 of the CEDAW, the Convention on the Elimination of Discrimination Against Women, because I like to see the Convention on Enforced Disappearances being read in a complementary manner with the Convention on the Elimination of Discrimination Against Women. And Article 7 is an article that looks at the rights of women in political participation and in public life, and the rights of women and the freedom of association of women in the public and the political life of their countries. And that is central to an understanding of the ways in which women human rights defenders have a role to play in the enforcement of all of the conventions that I have been speaking about, but in the front line of the protection of those disappeared. So in order to ensure that the Convention on the Protection of Enforced Disappearances is being fully fulfilled and actualized, we need to also see it in line with Article 7 of the CEDAW. So my final recommendation and my final call to action is can we look further and we look at the interstices, look at the ways in which those blurred areas, the gray areas of these intersections, and look at how we can address the rights of all women, including the women who have been disappeared and those women who are at the front lines as human rights defenders for those who have disappeared. So this is a call back to 40 years ago when 14 women marched in the Plaza de Mayo. So it is their legacy that we carry, and it is their legacy that we need to honor today through this forum.
Professor Da Silva, thank you so much for humanizing the issue that we're discussing today, presenting specific cases of women that have suffered in some way from the issues and the human rights challenges that we're discussing today. And I love the concept of reimagining the world, of having the opportunity to do that. And I actually want to ask a final question to the three speakers today based on this reimagination of the world for 3-minute answers. I know it's very short, but we want to hear from Mariam, and we also want to give our audience the possibility of asking questions. So one question, Carmen Rosa, that I wanted to ask you is, if we're thinking about this opportunity to reimagine the world and to actually think of a new world based on all the changes that we've had with COVID-19 and all the challenges, where is the role of the United Nations in this new world? Especially thinking of the issue that is the topic of discussion of this panel, enforced disappearances and human rights.
Muchas gracias, Rosa, por tu pregunta. Me parece muy importante el mundo. Muchos dicen que es un antes y un después. Sin embargo, como ya lo dije al principio, lamentablemente las desapariciones forzadas no son de hoy, son del pasado y existen en el presente. ¿Cómo poder abordar desde Naciones Unidas toda esta temática de la desaparición forzada y cómo hacer que los estados cumplan de manera efectiva con sus obligaciones en materia de protección, en materia de verdad, de justicia, de reparación, tal como lo establece el artículo 24 de la Convención para la Protección de todas las personas contra las desapariciones forzadas. Y esta preocupación subsiste evidentemente frente a las acciones que el comité emprende en el marco, por ejemplo, de las acciones urgentes, cuando al recibir una información sobre una desaparición forzada, trata y de hecho le escribe al Estado y le pide explicaciones sobre la desaparición forzada de determinada o la desaparición que se alegue sobre determinada persona. Y ahí hemos encontrado una serie de dificultades reales y también en el marco, sobre todo, de la pandemia, relacionadas con las dificultades de poder acercarse, por ejemplo, a las personas privadas de libertad, por ejemplo, incluso a las mujeres, a las niñas, tal como lo ha señalado la doctora Ranguita. Es muy importante y hay todo un desarrollo frente a toda esta nueva visión del mundo, porque hay que tenerlo así, hay que tenerlo claro. Estamos frente a un mundo diferente y tenemos que adaptarnos a ese mundo diferente, un mundo en el que nos llaman a la solidaridad, pero la solidaridad no es tal, en un mundo que se le llama a los estados cumplir con sus obligaciones y sin embargo se encuentran con una serie de obstáculos para hacerlos realidad. En ese marco y tal como hemos venido trabajando y sobre todo teniendo presente qué es lo que tenemos que enfrentar, hemos desarrollado una serie de guías que son ocho guías que no las voy a desarrollar todas y menos en 3 minutos, pero quisiera insistir en estos elementos, la importancia de no suspender frente a una denuncia o aún solo sin denuncia, frente al conocimiento de una desaparición forzada, una inmediata intervención. Y aquí juegan un papel muy importante la oficiosidad, la inmediatez, la eficacia de la búsqueda, porque son elementos que francamente no siempre son ni eficaces, ni inmediatos, ni exhaustivos como uno quisiera que fueran. Pero sobre todo la búsqueda no puede tener en estos ambientes y en este confinamiento en el que todavía vivimos en muchos países, mediano, máximo o con ciertas libertades, no puede tener como excusa estamos en pandemia. Lo que hay que tomar son las medidas necesarias para proteger a los funcionarios y proteger a los familiares y sobre todo para brindar información. ¿Sabes lo que más reclaman los familiares? Y una de las guías es justo insistir en la importancia de brindarles información. Es decir, hay miles de oportunidades. Estamos usando nosotros el Zoom. No todas las personas pueden usar el Zoom, pero sí pueden usar un teléfono, sí pueden usar el Internet, sí pueden comunicarse con las personas privadas de libertad. Y en este ámbito de la búsqueda de personas desaparecidas, y ya lo dijo también Ranguita, el año pasado el comité adoptó estos principios básicos para la búsqueda de personas desaparecidas. Son 16 principios. Y uno de los principios que ha sido mencionado por Ranguita también ha sido el principio número 4, que tiene que ver con la interseccionalidad, es decir, tener en cuenta esas diferencias, grupos LGBTI, grupos indígenas, grupos con mayor situación o una situación de vulnerabilidad y que también se recogen, por ejemplo, en el principio número 2 o en la guía número 2 que ha elaborado tanto el comité como el grupo de trabajo sobre desaparición forzada. Aquí no nos podemos quedar inertes. Obviamente, quiero decir que casi ya llegamos a mil acciones urgentes que ha recibido el comité. Tiene lamentablemente 2 países que son los que tienen más número de acciones urgentes, como son Irak, México, también tiene Honduras, Colombia. Y en todos estos casos, lamentablemente nos hemos preocupado porque en el marco de la COVID estos casos desaparecen. O sea que la COVID ha creado nuevos y preocupantes escenarios para las desapariciones forzadas. Y estas 8 directrices, sobre todo, están dirigidas a instar a todos los actores involucrados a seguir las mejores prácticas. Evidentemente, también está la posibilidad de existir mecanismos de coordinación, por ejemplo, entre quienes buscan, que no siempre son los mismos, y entre quienes investigan, en tomar todas las acciones posibles y en el marco de esta situación que a todos nos aflige, nos preocupa, por lo que el impacto que puede tener, es importante, sobre todo, tomar medidas eficaces de protección de salud para los agentes del Estado, pero no solo para ellos, sino también para las víctimas y las organizaciones de la sociedad civil, porque muchos de estos trabajos de búsqueda no se hacen por teléfono, no se hacen a través de una relación como la que estamos teniendo ahora, se hacen visitando los lugares, yendo al lugar donde se supone que la persona fue desaparecida. O cuando, por ejemplo, se produce una detención, ya lo definió también muy claramente Nerea, ¿de qué estamos hablando cuando hablamos de desaparición forzada? Es una detención, pero una negativa a decir si esa persona se encuentra detenida. ¿Cómo acceder a los registros si estamos lejos? ¿Cómo poder tener la posibilidad, sobre todo, de desarrollar medios necesarios para decir, a ver, estas personas están siendo detenidas, ¿dónde están? ¿Con quiénes se han comunicado? ¿Cómo comunicarse? Y que ha tenido un fortísimo impacto, por ejemplo, ha sido en las personas también privadas de libertad. ¿Cómo poder lograr que las personas privadas de libertad tuvieran comunicación con el mundo exterior? Las personas privadas de libertad han presentado miles de muertos dentro de las cárceles, no solo a las personas privadas de libertad, sino a los agentes penitenciarios también. Entonces, ¿cómo encontrar mecanismos alternos, reales, posibles, de seguimiento para que las personas no desaparezcan? Los principios rectores son un elemento importante y yo quisiera destacar sobre todo 4 principios rectores que me parecen fundamentales y que permean los 16 principios rectores. Es la búsqueda con presunción de vida. El tiempo que pasa es el tiempo que se pierde. Si tú no buscas, las posibilidades de encontrarlas con vida se reducen enormemente. Y la segunda es el deber de respetar la dignidad humana. Es decir, cómo tratas a las personas cuando te señalan o se acercan a ti para decir que una persona ha sido desaparecida. Cómo tratas también los restos de las personas que ya han sido localizadas, lamentablemente fallecidas, y cómo esa empatía entre quien es funcionario, en quien atiende, los forenses y todos los que forman parte de este engranaje, se comportan con relación a la víctima. Y el tercero es la búsqueda con enfoque diferencial al que ha hecho también mención, perdón, Ranguita. Pero los otros, por ejemplo, el vínculo entre la investigación y la búsqueda. Muchas veces se busca y no se investiga, o se investiga sin buscar. Por eso yo he acuñado una frase que después de mucho pensarla y que tiene que ver con este tema, es que buscar sin juzgar es impunidad. Y juzgar sin buscar es inhumanidad. Es justice without search is impunity. Searching without justice is inhumanity. Ese para mí son cosas básicas, importantes, y bueno, tendríamos mucho que hablar, y había preparado un PPT para presentar sobre todo los principios o las guías que me parecían importantes, pero hay un elemento relacionado sobre todo con las víctimas, sean niños, niñas, adolescentes, mujeres, y es que hay que establecer mecanismos para protegerlas, proteger a los testigos, protegerlas de las amenazas y de las represalias. Quienes han sufrido mucho en este contexto han sido los defensores de derechos humanos, los periodistas en este marco y sobre todo los manifestantes, quienes han salido a las calles frente a diferentes situaciones y que han sido reprimidos, pero detenidos y en muchos casos preocupados, además, porque no se sabe su destino, ni su suerte, ni su localización. Entonces, la tarea es enorme y en temas de desaparición forzada no podemos quedarnos mirando o estando solo como espectadores. Se necesitan acciones, se necesita un trabajo muy proactivo de parte del comité, de parte del grupo de trabajo, y ahora también estamos inmovilizados y hay que poner las cosas en su exacta perspectiva. No hemos podido tener, por ejemplo, las sesiones regulares que se tienen en el marco del año, que son 2, se han tenido que llevar a cabo con muchas limitaciones, pero las hemos llevado a cabo con esas limitaciones. En segundo lugar, hay que tener en cuenta que ese diálogo con las personas, ese diálogo con las víctimas, tampoco se puede llevar con la misma fluidez que se lleva cuando se llevan a cabo las sesiones y de manera directa y personal. Esperemos que las cosas cambien. Es importante señalar también la situación de los migrantes, y esta es una preocupación tanto del grupo de trabajo y también señalada en las guías, y por supuesto, totalmente de acuerdo con la profesora Ranguita, hay que insistir mucho más en el enfoque de género en la búsqueda e investigación de las personas desaparecidas. Y esto tiene un correlato mucho más grande. Cómo trabajamos con jueces, con fiscales, que se apropien de esa mirada y de ese enfoque de género y de derechos humanos para que las investigaciones y las búsquedas no queden sesgadas simple y llanamente por una falta de conocimiento. Por eso es que necesitamos funcionarios capacitados, necesitamos gente que sea capaz de trabajar con seriedad, con prontitud y sobre todo con eficacia. Muchas gracias.
Thank you so much, Carmen Rosa. And it's so wonderful to hear, especially from a UN committee member, what the problem of enforced disappearances and COVID-19 means, you know, for a United Nations organ that really has the ability to make very important statements. And I just want to highlight a few things that you said. One of them is the importance to continue with this prompt search investigation of these particular human rights violations, the importance to treat family members with dignity and humanity, the importance of access to information, and the importance of that gender perspective and intersectional perspective that both you and Professor Da Silva have been speaking about. So Nerea, I have a question for you. two things that you think the Inter-American system of human rights should be doing to continue addressing the problem of enforced disappearances, especially in light of COVID-19. Two things.
Two things. The Inter-American system has been very active, as well as all the regional systems. And I mean, it has been an amazing time, like from this point of view, only like to see how the different courts have been coordinating the responses, and also the Human Rights Commission. I mean, there was like a webinar like among the African Commission, the Inter-American Commission, and even the ASEAN Intergovernmental Commission. Like this is for the Southeast Asia mechanism, which is not an independent like a commission, but they have like issue press releases, and they have called in the same, in the same sense as the UN for not restricting the rights, and when this derogation needs to be taken, to do it in accordance with international law and with the principles of legality, necessity, proportionality, and also timelessness. So that's one thing. And from the Inter-American Commission, and it's not because I have worked there, as well as some of the people in the audience, as Ariel Dulisti, and I say also Jorge Anaya, is because it has been really impressive. Like the resolution, the one 2020, where they really like address like all the economic and cultural and social rights, like from the health point of view, but also how the Commission recalls the states, like the obligations that they have under the Inter-American Convention regarding the restriction of rights, for instance, and the rights that cannot be suspended, as access to justice, which is really, really key. And also the creation of this mechanism or of observatory, like to see what the countries are doing in within this context. So it's the SACROI, by the acronym in Spanish. So I mean, I think they have been conducting hearings online. They have like issue press releases also, like to provide an update on what the states have not been doing well. So the thing is, like, the Inter-American system and the universal system, the UN system, have been doing a lot. Like for me, it's like what the states have been doing, like to protect human rights. Because as Carmen Rosa pointed out, like if all these mechanisms like were like complied with, we will be in another situation. So that's one thing. But regarding what Carmen Rosa and what the UN Committee on Forced Disappearance was saying, I think that this context has shown that there is a need for the justice system to have electronic files and to have the possibility to like file this file from a telephone or from the internet, at least the habeas corpus and some kind of key remedies, and more in the cases of enforced disappearance. And also to see how the state can protect the judges and the family members, like in this search, which this is one of also of the standards of the Inter-American system, like the obligation of the state to protect like family members, and also the justice sector. I think the justice sector is key in controlling the excessive power that some states might have. But also, I think, and this is my last point, I think that we have seen that this forced disappearance happen in states where impunity and corruption are predominant. So I think that those are the key issues that international and regional like organizations need to try to work in the future to tackle, because those, I mean, in every, I mean, they have a direct impact in every right and including in forced disappearances. Thank you.
Thank you, Nerea. And I actually have a last question for Professor De Silva. And it's related to state obligations, you know, what Nerea was just talking about, right? We are imagining the world, right? We're thinking about this new world and we're thinking about state obligations and their positioning in this new world. How do you reflect gender and race considerations and that gender and race perspective that states should have, you know, in adopting any sort of responses to times of crisis, but also times where we don't have this kind of crisis? How do we make sure that these are fixtures in the new world? And that's our last question before we actually have commentary from Mariam Nagra.
So Rosa, as we know, COVID has deepened the fault lines on race and gender and exacerbated gender discrimination and race discrimination. But it has also brought to the forefront the pressing need for a new world order that is codependent on multilateralism as well as gender equality. So as we know, the evidence is clear and the case for women's leadership is now very clear. Countries that are doing the best right now in this moment in time are the countries that are led by women. So if there ever was a case for women's leadership, I think we've established that for all time. So in order to look at the more kind of macro level ideas of how can we rebuild the world along gender and racial equality and along the lines of how these intersecting dynamics create double, triple, and multiple forms of discrimination, I think it is important, and I so apologetic that I did not follow Carmen Rosa's commentary because I know it was very important and impassioned. But what I also want to remind everyone is that as we speak against the backdrop of the 20th anniversary of the Women, Peace and Security Agenda, the Security Council Resolution 1325. The UN is celebrating it right now. And Amina Mohammed, the Deputy Secretary General, as well as Phumzile Mlambo Nguka, the head of the UN, are traveling virtually to Colombia to look at the peace process and women in the peace process. And I would like to, kind of a radical restatement of the world to look at how more women can sit at the peacemaking table and in conflict resolution, but also more women who are either victims of who have been disappeared and then brought back, or those women whose families have disappeared sit at the table so that they can create peace treaties to address the rights of the disappeared and the rights of their families, including the right to access to justice and the right to build a stronger rule of law. So on those lines, and again, because I think it is so important to keep recalling their names and their stories, I want to end with the words of Nazreen, who reminded the world that as a deadly virus sickens my country, I throw my hands down and as a citizen in a gentle voice, I ask the government to end their animosity with the world, to look at the world through the eyes of peace. So on those lines of how can we rebuild the world, reimagine and redefine the world through a vision of peace and multilateralism, I like to say that that is my charge, Rosa.
Thank you so much. And I think we're all working towards a world of peace and in a world that we are free from enforced disappearances and that these enforced disappearances are properly investigated and sanctioned and prevented. And in a world where we have more women's leadership as well, right? So now we're going to move on to Mariam, who's actually going to provide some commentary and reactions. And for those of you that have questions, please write them down because we'll have time for some questions, at least 2 questions. So please write them down. And Mariam, you have the floor.
So first, I want to say thank you to our panelists for this great discussion. I'm conscious that 45 minutes cannot suffice to discuss such a technical issue to the fullest extent, but I think we will all agree on the fact that they did it brilliantly. And also, I want to say thank you all for attending the event. I hope you learned something tonight. And finally, thank you, Dean Celorio, because not only because you serve as the moderator, but because you literally encouraged me to organize this event, which was my very first academic event. And I'm sure it won't be the last. So talking about rebuilding the world, I want to focus my comments on the role that civil society can play in addressing this egregious crime. Well, egregious because, as Carmen Rosa said, enforced disappearances affect not only the disappeared persons, but also families, communities, and sometimes society, because they are part of the world where it is a strategy to spread terror, to eliminate political opponents, and sometimes to silence activists. So we know that states, because of their international obligation, have the primary responsibility of preventing, investigating, and prosecuting cases of enforced disappearances. And even in time of pandemic, these obligations remain the same. However, the reality is different. And in many countries, containment measures adopted to fight against the COVID-19 pandemic and the deployment of security forces to control the implementation of these measures have had a risk. It created an additional risk for enforced disappearances. And in certain places of the world, these measures have been used as a cover for enforced disappearances. So we observe that the issue may change in its form, but at the end of the day, it remains the same, and it remains poorly addressed by international and domestic laws and policies. So for that reason, I believe that civil society actors, because they work closely with families members, with survivors sometimes, need to have a space in the decision-making process. And in time of pandemic, they support financially victims. They also provide for legal assistance, which is really important, as Nerea mentioned, because in some country where impunities and there are a lot of impunities and corruption, it's really difficult to find justice. Disappeared person may be fined, but justice is another process. So civil societies actors can play a role in helping states to adopt more comprehensive and a center-based laws and policies, which are really important, because sometimes when we discuss about laws, when we discuss policies and even international treaties, states tend to put their own interest first. But what we want in those kind of issues is really a victim-centered approach in order to address the issue efficiently. So finally, I think civil society also have a role to play in advocating, in spreading awareness, and in providing sometimes indications and information that enforced disappearances is being practiced on a widespread or systematic basis in certain states. So that was my contribution tonight, and I hope you all learned something tonight. Thank you.
Excellent.
Marian, thank you so much for sharing all of that with us, especially highlighting the powerful role of civil society. I mean, at the end of the day, when we are discussing any human rights issue, civil society is one of the most important actors in society, not only to document, but to reveal information and to also expect from the government better behavior when it comes to their positive and negative obligations in human rights. So I really appreciated your commentary. And it's also wonderful also to see you and other students at GW engage with these issues. This is what we need as a step to resolve them as well. We can take two questions, and I actually have two questions in the chat. One of them is from Rago Areda, and he's asking, is there any practical action on enforced disappearances that require states to adopt laws, policies, and practices that are grounded on these principles? And by principles, I want to say equality and non-discrimination. Any of the speakers want to take this question? Nerea.
I can begin, and I'm sure that Dr. Villa and also Dean Da Silva can complement. Well, the answer is civil society organizations. So civil society organization can request the states to ratify international conventions and regional conventions. So within the regional convention, the Inter-American Convention on Forced Disappearance, and also the UN Convention on Forced Disappearance, and also, I mean, in all the convention, there is an article that says that the state who has ratified that treaty need to adopt measures to comply with that treaty. And this is also the under the Vienna Convention on the Law of the Treaties. I mean, like the obligations that the states like assume through the ratification of this treaty need to be done in good faith. But who controls the state? With civil society organizations. So, and also like in the same sense that Marianne has pointed out, is like why do we have such a comprehensive jurisprudence in the American system on forced disappearance? It is because of the plaintiff. And who have been the plaintiff? Civil society organizations and victims of the disappeared. Also the commission has helped a lot. I think that in this continent is good to have a commission and not only a court. So I think, but civil society organization really runs the state, or push the state to like comply with international norms, to adopt this kind of principles. Also like the UN, like also is an impressive forum for the civil society organization to talk with the states at the same level, because it's very difficult to do it in your own country. So sometimes you don't have the opportunity, but you can do it at the regional, at the UN level. So I think that that's one of the ideas, but I will leave Dean Da Silva and Dr. Villa. Thank you.
Well, we have another question, and this is our last question of the night, and it's from Luis Enrique Mendoza Choque, who's also one of our students. He's asking, during the pandemic, what are the measures the Inter-American system is taking to monitor its previous resolutions on enforced disappearances? In Peru, we have the case of Ernesto Castillo Páez, in which the responsible were only in prison for 6 years. Ernesto's relatives want a hearing for supervision purposes. Any of our speakers want to take that question? Nerea.
Sorry, it's not that I want to take the space, but well, the Castillo Páez case is a case that it has already Inter-American Court decision. So it's up to the court to provide that. It's like follow-up hearing, like with the state. And normally the court like conduct this kind of hearing certain like once a year or every 3 years to see the time. And unfortunately, this is very different from the Council of Europe and from the European Court on Human Rights. In the European system, it is up to the Council of Foreign Ministers like to like look and oversight the compliance with the European Court decisions. Mm-hmm. In the Inter-American system, it's up to both the two main human rights organs to do it themselves. So I think that that's something like to push. And I agree absolutely that this court decision needs to be complied with. Thanks.
Well, Carmen Rosa, do you want to add something? Or yes, go ahead.
De acuerdo a la pregunta que ha hecho el señor Mendoza, efectivamente se está pidiendo que se siga o una audiencia de supervisión de la sentencia. Yo creo que hay un elemento fundamental y es que hace poco se ha conmemorado la lamentable desaparición de Ernesto Castillo Páez y fecha hasta el día de hoy sus restos no han sido encontrados y la búsqueda continúa. ¿Cómo lograr la efectividad de la justicia? Porque yo quisiera señalar que nosotros tenemos a lo largo de la historia y en muchos de los países que han vivido bajo dictaduras, una deuda pendiente con los casos de desapariciones forzadas. Y esa deuda pendiente, lamentablemente, hoy día la búsqueda, después, en caso del Perú, 36 años después, la gente y los familiares, los allegados, siguen buscando los restos. Y quiero decir algo más y más preocupante todavía, y es que los siguen buscando con la esperanza de encontrarlos con vida después de 36 años. Hay que imaginar la angustia, la desesperación de estas madres, porque en la mayoría de los casos, y ahí justo en la línea lo que llamaba Ranguita, y son las mujeres, las cabezas que quedan como cabezas de familia, las que se encargan de la búsqueda y cambian su proyecto de vida de la noche a la mañana, dejando muchas veces aquello que era importante para el hogar, a los hijos, a las hijas, para dedicarse a la búsqueda, ya sea del esposo, del hermano o del hijo que desapareció. Pero hay un tema que se ha hecho y que es muy importante, que ha hecho el señor Rago Arreda respecto a equality and non-discrimination. This is a pillar of the human rights in all treaty bodies. Since the human rights declarations, at the beginning of this preamble of the Human Rights Declaration, we are equal in dignity, and we need to preserve this kind of principle. We include all of this equality and dignity and non-discrimination in CEDAW, in the Convention Against Racial Discrimination, and in the protection of the person with disabilities. We think that we don't have any mechanism that doesn't include the discrimination and non-discrimination and equality as a principle, as a key pillar in our work. I think that in this case, the different mechanisms that we create and different guidance that we develop around the world, I think that it's important to include this and to have in front of our face non-discrimination and equality, and the main issue that we need to raise always. For example, in the guidance, this is in Spanish, I can show you, but I don't have it, it's a different kind. This is in the guidance. We try to, in the government, when we have dialogue with governments, we insist in the importance to appropriate this kind of guidance. This is not only very nice book or very nice principles or guidance. This is important to include in their daily work this kind of principle, this kind of guidance when they searching, when they investigating, in every work that they are doing, the authorities are doing. And the same thing is important to have on board the civil society, the families, the relatives, and to insist in front of the government to request, we need to be a part of this investigation. We need to participate in this investigation. As Ariel Dulinsky said in this charter or chat, he said that it's important to take into account the social and economic and cultural rights when we talk about enforced disappearances too. Okay, we have incredible documents that we need to know exactly what they are telling us to be our work better. We need to create some kind of environment to insist with governments and to create confidence with the civil society, with national institutions, for example, and with all groups that are working on enforced disappearances. Thank you so much.
Thank you, Carmen Rosa. I think that's the best way to end this discussion this evening. Thank you so much to our wonderful speakers. Thank you so much to Mariam for organizing this event. Thank you to our Human Rights Law Society and our International Law Student Society who co-sponsored this event. And thank you all for joining us this evening. We keep on working on these issues. Have a good night.
Thank you so much.
Thank you very much.
Gracias, Rosa.
Gracias a ustedes.
Gracias, Rosa.
Thank you.
Thank you, Mariam.
Thank you, Marian.
Thank you.
Excellent presentation, comments. Thank you so much.
Wonderful. I'm so proud of you.
Thank you.
Yeah.
Bye.
Bye-bye.
Bye.